All right, let's begin this morning. I'm Judge Jackie Powell. Let's begin with our juvenile docket. We have two to address this morning. And so the first is DeAndre Lodge. Where's Mr. Lodge? If you just stand up, you can stand where you are. That's fine. All right, so Mr. Lodge, you have a new law violation, resisting officer without violence, and I find probable cause for that charge this morning.
Services.
Yes.
DeAndre and his aunt are willing to enroll in our services while he's on home detention.
Okay. All right. All right, so Mr. Lodge has 12 points, which lands him in supervised release. With the electronic monitor. And what is your service? I'm sorry again?
Juvenile predisposition services with the county.
Okay, all right, so, Mr. Lodge will have supervised release with, the electronic monitor, okay? All right, and your service is yes.
Thank you, Judge.
His next court date is February 19th at 8:30 before Judge Revolt.
You heard that, February 19th, before Judge Rebola, okay? And then the next person we have is Mr. Headley. So I don't want to butcher your first name. So Mr. Headley has a new law violation for assault on public or private education employee and battery on a public or private education employee and resisting officer without violence. Yes.
It's going out over there. I'm sorry.
It should. We have more- All right, good morning, everyone. I'm Judge Jackie Powell, and this is first appearance court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not your trial date, nor is it an adversarial hearing. And so because of that, I need to let everyone know that everything you say in this courtroom today is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, we do have attorneys available. And Counselor in the courtroom, I'm going to ask you to please announce your name on the record.
Morning, Judge. Ryan Dessler, Assistant Public Defender.
All right, and over at the main jail, please announce the public defender.
Uzma Gomez, and for that record, the first name is spelled Uzma. Good morning, Your Honor.
Good morning, Ms. Gomez. And so these attorneys are available not only to the persons at the main jail, but also to the persons at the other facilities, and at the other facilities, the attorneys are available to you by phone. Some of you may have private counsel. Those attorneys will come to the courtroom and will be able to address your case from here. Those of you, you also need to know that in the courtroom with me this morning, we have attorneys from the State Attorney's Office, and we'll ask those attorneys to announce themselves on the record.
Yes, Judge, good morning. Kristen Gomes, Gomes.
Aaron Passy.
All right? And also in the courtroom, I have representatives from confinement status, pretrial supervision, and the clerk of courts, and all these persons are here to help facilitate this morning's hearing. All right, if you have private counsel and your attorney is not here, you can let me know. We'll see if we can reach them. If we can't, your case may have to be reset. But please don't tell me that you have private counsel unless you or your family have in fact retained private counsel, all right? For those of you who are charged with misdemeanor cases and municipal ordinance violations, depending on what's going on with you personally, you may be able to resolve your case today. But we won't know what that is, whatever is going on with you, until I get to you and we are able to address you individually. All right? So when I call your name, I'm going to ask you to come up, and then we will address your case. There are... Yes.
Your Honor, good morning.
Good morning.
Sorry for the interruption. Here at the main jail, the deputy said requested that 3 people be called out of order for safety concerns, if I could give you the names.
Okay,
The first one's on page 15, it's Mr. Reynolds.
okay,
18, Mr. Weston.
okay.
And on page 20, Shepard. And 2 other things, Your Honor. I was called to get one person out of order. He's here on page 20, Mr. Morales. I think somebody from the state wants to see him. And lastly, the MOPD called in, and she's on her way. She asked if Your Honor could set aside any MOs, and she will be here shortly.
All right, thank you very much.
Thank you, Your Honor.
All right, so let's begin with Robert Reynolds. It's one of the persons I've been asked to call out of turn.
He's in a wheelchair. They're bringing him up.
Okay. All right, Mr. Reynolds, you're before the court this morning. Charge 1 is domestic battery by strangulation. Number 2 is grand theft auto. Number 3 is fleeing with disregard of safety to persons or property. And number 4 is grand theft auto. This court finds probable cause. And I'll hear from the parties if anyone wish to be heard in regards to the bonds.
Yes, Your Honor. Mr. Reynolds cannot afford a monetary bond. He can be placed on pretrial release. We asked it for it to be standard, and he does have medical conditions, which might be difficult for him if he were to stay in custody to deal with, mainly Parkinson's and epilepsy. And he does not live with the alleged victim in this case. Any reason to contact her?
No, I have no
And and he states that he has no reason to be in communication with the alleged victim.
All right, state.
Your Honor, the state's asking for a $7,500 bond on counts 1 and 2, and on counts 3 a $5,000 bond, and on count 4 keep the $1,000 bond in place.
All right, the allegations that I have before me states that the defendant entered the driver's seat of the vehicle, at which time the victim stated to the defendant, "Don't take my car," and approached defendant, who was seated in the driver's seat with the door open. Defendant then grabbed victim by the throat against her will, restricting her breathing and blood flow. Victim broke free of this grasp, ran to the front passenger seat, entered the vehicle, at which time defendant again knowingly and intentionally grabbed her by the throat against her will, restricting her breathing and blood flow to the point where she lost consciousness. Victim then regained consciousness while still in her vehicle, at which time the defendant pushed her out of the vehicle and drove away from the listed location. Based on the allegations that I have before me this morning, I am going to impose a $7,500 bond on charge number 1, $1,000 bond on 2, $5,000 bond on 3, $1,000 bond on 4, no victim contact. And sir, no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yeah.
Okay. All right, Antonio Weston.
He's on the way, Your Honor.
Thank you. All right, good morning, Mr. Weston. Sir, you're before the court because you have 2 misdemeanor cases that were issued earlier this month. One charge is trespassing, both of them are trespassing, and both were issued January 22nd of this year. What does Mr. Weston wish to do this morning?
He would like to see if he can resolve his case
Is-
with credit time served.
Is there an offer?
The state would offer adjudication 30 days, any credit time served, on both counts, all cases.
What priors does he have?
I would need a moment, Judge, but
Or tell me the most recent.
They are all within the last 15 priors here in Broward County, all within the last, about 6 months to a year are trespasses. I count trespasses and the last year there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. About 20 arrests.
All right, if Mr. Weston wishes to resolve his case, he'll be 5 days in a Broward County jail. Does he wish to accept that?
You'll do 5 days?
yeah.
He'll wish to accept that, Your Honor.
All right, so Mr. Weston, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Weston, do you understand the sentence and that has been, the offer that has been extended to you today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yeah.
Have you ever been treated for mental or emotional illness?
No.
do.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
You understand that?
Yes.
What plea do you wish to enter at this time? Guilty or no
No
contest?
contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to both counts, adjudication 5 days, Broward County Jail, to run concurrent, all right?
Clarify, that's on case 3860, Your Honor, and 3853. It wasn't one case, two cases, two separate cases.
Oh,
Same thing.
it's same,
It
okay,
will close out both those cases.
yes,
Thank you.
thank you. Anthony Shepherd. Yes, thank you. All right, Mr. Shepherd, you're before the court for an ad charge. This is now charge number 6 for a violation of felony probation. It does have a no bond hold, so I find probable cause, and you will see your division judge on February 6th in regards to that VOP. All right?
And Your Honor, I'm being told that he's also on page 32.
Is he on page 32?
Yes. Fourth to last on the docket, I'm told.
All right, so, on this one, it was a reset for a bond. Judge Coffin already found probable cause, and for some reason, the bonds, were not addressed, so let's address the bonds at this time.
Your Honor, given that he has the VOP no bond hold, will leave the bond as I have on count 2, 3, and 4 to be $1,000 each, and ask that count 1 be the same.
All right, on count 1, I'll set a $2,500 bond, okay?
Thank you, Your Honor.
All right. All right, Jesus Morales.
He's approaching, Your Honor.
All right, Mr. Morales is before the court this morning, and these are ad charges. Charge number 3, robbery with a firearm. Number 4, attempted felony murder. And number 5, burglary for dwelling or structure or conveyance armed. I find probable cause.
Your Honor, Eric Linder on behalf of the state. May I approach briefly?
Certainly.
And Your Honor, the photos I provided the court, I showed to Mr. Dessler already.
Seen it.
Okay,
Your Honor, Mr. Morales is charged with 3 punishable by life offenses. I believe the probable cause affidavit that was authored by Detective Cook of the Hollywood Police Department, who is also present in court. If the court feels that you would need to hear additional testimony aside from what's in the probable cause affidavit, the state does believe, though, that the evidence contained therein contains certainly ample evidence from multiple sources to satisfy proof evident or presumption great on these 3 charges, and the state would be seeking a no bond hold for first appearance purposes.
Remind Your Honor that according to the 4th DCA, proof and presumption great, which is the finding the state's asking for this morning, goes beyond a reasonable doubt standard. And so the contention is from the state that if they went forward to a jury trial today, not only would they win convincingly. It's up to Your Honor to decide if the state's met that burden as of this morning.
well, this is a preliminary proof evident presumption grade. And I do find, I'll make that finding. It's a preliminary finding of proof evident presumption grade. It is without prejudice for Mr. Morales to have a bond hearing before his division judge. The case law does provide that the first appearance judge can make that finding and also allow them to have that author hearing. So at this time, I make that proof evident presumption great, and as I said before, without prejudice for Mr. Morales to have an author hearing.
And Your Honor, if I could, just for record purposes, I meant to mention this earlier. If you know, I would note on the photo showing the top of the victim's scalp, you can see in the lower right corner of his scalp the circle which indicates where the bullet from the gun that Mr. Morales fired struck his skull and then went along his scalp, and you can see the scar on his scalp also. So I just wanted to note that on the record.
All right. Do you need your photos back? Because I don't think the
Well-
clerk, does the clerk?
I'm gonna ask for them back just in abundance of caution. I believe Your Honor's gonna be calling Mr. Pierce's case next.
Right.
I'm just gonna ask for them after that.
So John Pierce?
And Judge, just for Mr. Morales, it'll be for Mr. Pierce also, we're gonna invoke their right, or for Mr. Morales, we're gonna invoke his right to silence.
Right.
And Your Honor, even though it was ordered already on the first two counts, I don't know if this is all gonna be under the same case number. So in abundance of caution, I'd ask for an order of no victim contact.
All right, and so, Mr. Morales, no victim contact, this means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, Your Honor.
All right, so, John Pierce,
He is in Conti, Judge.
Mr. Conti,
And Judge, I spoke to Mr. Pierce this morning. He has a private attorney on his case. From my understanding, what he wants to do is he wants to reach out to his wife to get the private attorney here. I'm gonna ask for it to be reset for Monday.
Your Honor, in fairness, and I would just want to bring to the court's attention, I was here I want to know for the record, this defendant, his name is not John Pierce, his name is Julian Brown. I don't know how, but BSO was provided the name John Pierce. At his first appearance, there was no mention of a private attorney. There was no mention of communication with his wife about hiring a private attorney. He went with the public defender at his first appearance,
when was that?
Thursday.
And just so to note and be clear that the probable cause affidavit does have Julian Arma Brown as the name and the AKA John Pierce on the record, okay? All right, and so Mr. Brown, AKA John Pierce, has been in custody since Thursday. These are now additional charges. Sir, have you retained private counsel at this point?
I spoke to my wife and she says she has, so I have to call her again to inform her about these charges.
Well, did she give you, you retained private counsel for the charges that you knew about on Thursday, is that correct?
Yes, but they weren't able to find me because of the wrong name.
Do you know if your wife actually paid a retainer fee to the attorney?
I'm not 1,000% sure, but she's definitely spoken to a private attorney.
She's spoken to them. All right, okay, so, for this morning's purposes, I am going to also, as with the co-arrestee, make a preliminary finding of proof evident presumption grade.
Judge, I would object to the finding. I don't know if I'm standing in as his attorney or a friend of the court, but if he's requesting to have a private attorney here, he's gonna be held no bond.
Sir, he's not requesting to have a private attorney. He's
he's-
saying that he's saying that he believes that his wife has retained counsel. If he has not retained counsel, he doesn't have an attorney.
Even if it's his intention to hire a private attorney, he's allowed to request to be held no bond. He's not going anywhere. If it's any defendant's allowed to be represented by who they want.
Okay, so are you asking for your case to be reset till Monday for you to have an attorney? Is that the request?
My request was for it to be reset to Monday because we have a private attorney. My wife has one.
All right, well,
However, I would ask then that the hearing be reset for tomorrow. He can certainly get access to his phone to call his wife to tell the attorney to be here tomorrow.
I will reset for tomorrow. All right? All right, so now do you want your photos back?
Yes, Judge.
Okay. I don't want to give it to the clerk. All right, Taylor Thompson.
Good morning, Your Honor. Steve Melnick on behalf of Mr. Taylor Thompson. We had requested a bond of $25,000 on each felony count. The two traffickings reduced from 75 to 25, and I believe the state had no objection to that. Is that correct, Ms. Gomes?
All right, so Mr. Thompson is before the court. Charge one is trafficking in heroin, 4 grams less than 14 grams. Number two, trafficking in MDMA. Number three, possession with intent to sell, manufacture, or deliver cocaine. Number four, possession of oxycodone. Number five, possession of cannabis, over 20 grams. Number six, possession of drug paraphernalia. Number seven, obstructing police. I find probable cause for those charges based on the agreement with the state and defense. I will ratify charges one and two at 25,000, and then the other remaining bonds remain.
Thank you very
Right.
much, Your Honor. Have a nice weekend.
You
Thank
too.
you.
Right. All right, Glenn Speecher. Good morning.
Forward there.
All right, Mr. Spicher.
There he is.
He's approaching, Your Honor.
And Your Honor, Mr. Spiker's son, here in court, this is not the alleged victim, this is his other son that he's here.
I'm sorry, the sound is, what was that?
Mr. Spiker's other son, Russell, is present in the courtroom. This is not the alleged victim in the case.
Okay.
This is just his other son. He's present.
Okay, all right, so Mr. Spicher, is facing, touch or strike battery, domestic violence. Number two is aggravated assault with a deadly weapon, also domestic. I find probable cause.
Your Honor, I have submitted to the state, if Your Honor wants a copy, I have only 2 copies. It is a notarized affidavit of non-prosecution from the alleged victim, Joshua Spicher, that has been provided. I also want to point out to the court that this case originated when my client went to BSO to get a Baker Act initiated against the alleged victim. He comes out to the house and he takes a statement from the alleged victim, who then says his father had done this with the firearm, which allegedly occurred days earlier. The alleged victim never called 911, and my client never admitted to placing the firearm in his mouth, only admitted, according to the arrest affidavit, to pointing the firearm at him. So we have a conflicting account with really no independent evidence. Also an affidavit of non-prosecution, which in my experience kind of tells me where this case is going. He's got no prior history, Judge. I'd ask for ROR on the misdemeanor and a $3,500 bond on the aggravated assault. The alleged victim will not be living with my client.
Okay,
No objection to the bond amount, Your Honor, but we would also like an order having the gentleman turn over his firearms to law enforcement by the pending of these prosecution. No firearms.
That's understood.
all right.
We'll address that.
So ROR on charge one, 3,500 on two. Mr. Spicher to surrender any firearms and no victim contact.
That's fair.
Okay?
Thank
All
you,
right.
Your Honor.
You're
Thank you,
welcome.
Sir.
Yeah, go ahead.
All right, counsel, you have a case? Because I'm going to start from the top and keep moving. Okay. All right, Rachel Goldfinger.
Good morning.
Good morning.
Good morning.
Good morning. Ms. Goldfinger is before the court for one charge of battery on a person 65 years or older. I found no information in the probable cause affidavit that tells me the age of the alleged victim. Only that she's the mother of Ms. Goldfinger.
Your Honor, if we could have 48 hours to perfect so that we can provide Your Honor with a birth date for the mother.
Judge, this is a 4-year-old case. This is a KPS
It's
from
a how
2000.
old case? Oh, that's
It's from
right.
2016. I was going to ask for Miss Goldfinger to be ROR. From my understanding, her and her mother are in constant communication. This is something the mother apparently tried to drop in the last 4 years. Like I said, I was going to ask for an ROR, even if Your Honor does want to still order no contact between Miss Goldfinger and her mother out of precaution. I explained that to Miss Goldfinger, that maybe they can't have contact until they see the division judge. But I'm asking for an ROR. This is something that's been,
I'll make a probable cause finding for battery
okay.
at this time, and I'll RR Ms. Goldfinger, and, ma'am, you need to make sure that you stay in touch with your attorney so that you know if and when you have to come back to court. Do you understand that? Also, it is your responsibility to make sure that the clerk has the correct information for you, so you need to make sure that that's available, because you can't come back and say, I didn't get notice because it didn't go to the right address or something, it's your responsibility to make sure that they have your information, okay?
Yes, ma'am.
All right.
Yes, ma'am.
Yes,
Judge, I think
no,
I
yes.
maybe I'm misreading this wrong, but I think she's already been magistrate. I think she's probable cause has already been found as to the.
Well, why is she here
She's
then?
capious. She's since capious.
No, I believe it's not in custody. It's a filed case, but this is her first time before a judge on it. Let me double check.
Okay, Your Honor.
All right, okay. All right, Sarah Weiss? Yes, okay. Sarah Weiss, Ms. Weiss is before the court on a misdemeanor capias, and the capias is for a petty theft charge. That capias was issued May 10th of 2018. So, what, Ms. Weiss does have a $500 bond.
She cannot afford that bond, Your Honor, but I did speak to her about pretrial release, which she's willing to do.
All right, State?
And she did not know she did not realize that she had a capias out for her this
Okay.
entire time.
Your Honor, she's been capious. She has 0 months residence at the address of which she provided. Your Honor, the $500 bond is.
I'm sorry, you're at the main jail. If you could turn the microphone off when you're, that way we can have a better sound here. Yes.
The $500 amount is a reasonable amount. She has 0 months residence at the address of which she reported to pretrial.
Oh, so she was on, oh, okay.
She doesn't have. What I'm saying
I
is she doesn't have a Broward County address. and
All
she's
right,
been
so
capious.
Ms. Weiss, you have a $500 bond. I'll leave that in place. All right, next is Tiffany King.
North Broward.
Ms. King, good morning. You're before the court this morning on a one charge, criminal mischief, and number 2, resisting officer without violence, and I find probable cause. You have a $100 bond. I'll leave that in place.
Thank you, Your Honor. And
All
we would
right.
just ask for also a no return to the address of 2930 Solano Avenue.
Did you hear that, ma'am? You cannot go back to that address.
Even to vacate the premises, it's my apartment.
All right, well, at this point, until everything else is resolved, no return to that location, okay?
Okay.
Keisha Willis, her bond has been posted. Oh. Keisha Willis,
Good morning.
good morning, Ms. Willis. You're before the court on a petty theft, second-degree charge. I find probable cause.
Your Honor,
Yes,
she's currently on pretrial in case number 19005609 CF10A for grand theft. Pretrial is asking that you revoke her pretrial.
when was she placed on pretrial?
I'm sorry, her division judge placed her October 29th, and her officer has been trying to get in contact with her. As of lately, she walked away from the program that she was in, and her mom and the program didn't know where she was.
Okay. All right, so Ms. Willis, I am going to grant pretrial's request to revoke your pretrial supervision, and I am going to impose a $1,000 bond. And the $25 bond on the new arrest will also remain. Today's the 1st of February, right?
Yes, ma'am.
All right, second month of the year. Paula Rocco,
Could be North Broward.
North Broward. Oh, there's a MO. All right, we're waiting for the attorney to show up. Thank you. We'll recall. And Deborah Arter.
All right.
Your Honor.
All right, good morning. And ma'am, you're before the court on a KPS for a misdemeanor charge. This KPS was issued January 21st, and the charge is petty theft.
Yes.
And Judge, I spoke to Miss Arter this morning. She was interested in potentially resolving this case this morning if she could. I know you might not have the probable cause affidavit. I can't print it out. I could read it to your honor if you would like.
All right.
It has to, let me see. So this is from December 12th, 2019. The PC, all it reads is at the above listed date and time, the offender committed the crime of petty theft when she walked out of Walgreens with $119.96 worth of merchandise, bypassing all points of sale. And they give the address of the Walmart,
Okay.
or excuse me, the Walgreens.
She wants to resolve the case?
Yes, Your Honor.
You have an offer?
Your Honor, the state would offer an adjudication, 10 days, Broward County Jail.
What is the basis for the 10 days? What is our priors?
There is a prior petty theft, that she resolved October.
That case was resolved in Judge Lerner Ren's division? Okay. All right, if Ms. Archer wished to resolve her case, there'll be adjudication time served.
You understand that, Ms. Harder? Did you hear the judge?
Could you explain to me exactly what it means?
That means your case will be done, you'll be out as today or as soon as possible that the jail can release you. Do you wish to accept that?
Yes, I do.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything we've discussed here today?
I believe I do.
Well,
Yes.
I don't want to know if you believe, I need to know if you understand.
Yes, I do.
All right, is anyone forcing you to resolve your case?
No, they're not.
Are you under the influence of drugs or alcohol?
No, I am not.
Do you need any more time to speak with your attorney?
No, I do not.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, I do.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, I do.
What plea do you wish to enter at this time, guilty or no contest?
No contest,
I
ma'am.
accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served. Good luck, ma'am.
Thank you so much.
Bree England. Oh, that's an MO case. We'll recall once the attorney gets here. Raquel Marriott.
Come on up.
All right, Ms. Marriott is before the court. Charge 1 is unlawful possession of personal ID of another. Number 2 is possession of cocaine. 3 and 4 are felony cases, and those have no bond holds. You are scheduled to see your division judge on February 4th. I find probable cause. The standard bonds on 1 and 2 will remain. Chelsea Fulton.
And for Ms. Fulton, Your Honor, I spoke to her this morning. She says she has private attorney Monica Lawrence. However, Ms. Fulton would like to go forward today and represent herself.
Ms. Fulton, when did you hire this attorney?
About 2 years ago, Your Honor.
All right. So 2 years ago, you did not hire the attorney for this case, correct?
No, ma'am. This case was just brought up yesterday.
Right. All right. So, Ms. Fulton, you're before the court this morning on one charge of confining a child under 13 years of age without consent of parent. Number 2 is touch or strike battery. 3 and 4 are false ID given to law enforcement officers, and I find probable cause for these charges.
And Judge, I do have present with me today Detective Pontigo with the Hollywood Police Department. The state is asking that you find proof evident presumption great. This is charged under the kidnapping statute. It is a punishable by life offense. The testimony, the evidence included in the PC is that a Good Samaritan actually also witnessed the kidnapping, ran out, and was able to fight off the defendant, potentially saving this child's life. The state is asking that, based on that, you do hold her no bond.
Okay.
Your Honor, may I say something?
She wanted to
Am I
represent
guilty?
herself.
Okay.
Your Honor,
Ma'am,
am I
let me just say this,
Your Honor, am I guilty
ma'am,
of
let me,
kidnapping my own child?
Miss Fulton, let me just say this
Yes, ma'am.
before, that everything you say in this courtroom today is being recorded and can be used against you at a later time. Do you understand that?
Yes, ma'am.
All right. And for today's purposes, you're asking to represent yourself today, is that correct?
Yes, ma'am.
You don't want the services of the public defender's office?
I can use them if I take it to trial, right?
Well, we're not talking about trial today. We're not even close to there. Today, we're talking about probable cause and bond conditions. So,
I don't have money for a bond. I just got out of jail 2 years ago about my child.
that's not what I asked you about. I'm asking you, are you rejecting the services of the public defender's office today?
Today, yes, but not tomorrow.
All right. Okay.
Your Honor.
Yes, ma'am.
I just want you to know that I've been fighting for my daughter for 5 years. There's no way I would have been in trouble all these years about nothing. I'm fighting for my daughter. That's all I want is my daughter from out of foster care. I feel like we should put foster care and DCF out of business and have somebody honorable and somebody real like a father figure in the hospital rooms because they're kidnapping our children and right from the womb. Right from the womb. I haven't seen my child in 10 years. And I've been fighting for her. And she's still under the concept of that's her mother. That's not her mother. I'm her mother. I'm her grandmother. I'm a grandmother now, and I'm proud to say that, and I'm not embarrassed of that anymore.
All right, Miss Fulton.
That's my child.
Miss Fulton, I have no proof of anything that you're saying today.
Well, we have blood tests. We can give a DNA test, right?
Well, will you let me finish?
Yes, ma'am.
I've allowed you to speak, so now it's my turn, okay? Today is not your trial, and if you do have that defense, after today, you'll have your time to develop your case so you can have a trial. For today's purposes, the allegations that I have is that...
My great-grandchild, ma'am.
Ma'am, let me finish. The allegations that I have is that there was a mother sitting at the dental office with her 2 children, and when she walked away with one, that the other one that was sitting there, that you grabbed that child and ran out of the dental office with another mother's child. If you have any other defense as to that, you will have time to prepare for a trial for that. For today's purposes, I do find probable cause, and I do find that there is a cause for...
What about my other charges? What am I being accused of? What am I in trouble for not selling dope? For not prostituting, for paying my rent with my little bit of Social Security money? What am I getting prosecuted for from the police for when I keep getting in trouble for no reason? Because I'm black in America? What do you want me to do, Your Honor?
All right, charge 1, I do make a preliminary finding of proof, evident, presumption, great, and Ms. Fulton will be held no bond as to that charge. Okay? All right, Teresa Williams.
Good morning, Your Honor.
Good morning, Ms. Williams. You're before the court this morning on a grand theft auto charge, and I find probable cause.
Judge, for Ms. Williams, the only Florida prior I'm able to see is driver's license suspended. That's one count that I saw. She's lived in South Florida her whole life. All her family's down here. I'm asking for standard pretrial.
All right, so I'll release Ms. Williams to standard pretrial. Ms. Williams, by Monday morning, you need to report to the pretrial office. The deputy will give you the information for the pretrial office. If you don't report, a warrant will be issued for your arrest. Do you understand that?
I understand, Your Honor.
All right, good luck, ma'am.
Thank you, ma'am.
Ashley Elise? Thank you.
She bonded, Your Honor.
Ms. Elise bonded, is that correct? All right, I find probable cause. Laura Clayton? All right, Ms. Clayton is before the court on a violation of a felony probation, and your judge Judge Casey did issue the violation with a $5,000 bond. So that's what you have, and if you don't bond out Before then, you have a court hearing with Judge Casey on February 4th at 8:30 a.m. Okay?
Okay.
Ruth
That's it?
Ann, yes, that's it. Ruth Ann
Thank you.
Palacios. All right, I've been informed that Ms. Palacios' bond has been posted. So Ms. Palacios, you're facing charge one is grand theft auto, number two is a traffic offense for which I find probable cause, and your bond has been posted. Abneris Martinez Vasquez. All right, Ms. Martinez Vasquez is before the court on one charge of burglary with assault or battery. I find probable cause.
And Your Honor, she is a resident of Broward County for 20 years. She is employed as a beautician, and she could afford about $1,500 bond, or she's willing to be placed on pretrial release.
This is a first-degree felony charge. Yes,
Judge, this is a burglary bat, which is punishable by life offense.
yes.
The state's asking that Your Honor find proof evidence presumption great, and that you hold Ms. Martinez Vasquez on preliminary no bond hold until she can see your division judge.
Judge, this morning, all the state has is the probable cause affidavit. According to the 4th DCA, what the state's asking for today goes beyond the reasonable doubt standard. I understand we're a magistrate court, but the standard's a standard. It doesn't matter if it's state, it's the same standards. If it was a full Arthur hearing, that the same standard must be met. I don't know if just a probable cause affidavit, the probable cause affidavit before us today rises to that level. Even if Your Honor still finds proof under presumption grade, it is within your discretion to still set bond. You do not have to hold Ms. Martinez Vasquez no bond. She has no Florida priors. Reading the probable cause affidavit, even if Your Honor does think the elements are there and the elements are proven by proof under presumption grade, I would point out to Your Honor, this isn't what we would necessarily think of as a burglary with a battery. It seems like it's more, arguably, based on the allegations before us today, more of a domestic violence situation.
All right, I will not, based on the allegations that I have, I will not make a finding of proof evident presumption grade. Let's talk about bond.
Yes, Your Honor. As I've mentioned, she is a 20-year resident of Broward County. She's by profession a beautician. She can afford about a $1,500 bond, or is willing to be placed on pretrial release.
The state would be requesting a $50,000 monetary bond, and if Your Honor is not inclined to place a monetary bond, we are
Can the
asking for a
state
level.
speak into the mic? We can't hear them in the main jail.
Sorry about that.
Is the mic on?
Yeah. Can you hear now?
Yes, I can.
Okay. The state's asking for a $50,000 monetary bond, Your Honor, and if Your Honor's not inclined to do a monetary bond, we would be asking for a level 1 GPS monitor. No return, no victim contact.
All right, based on the allegations, I will RR to pretrial on level 1, no victim contact, and no return to that location. Ma'am, no victim contact means no phone calls, no text messages, no social media contact, no third-party contact. Do you understand that?
Yes, Your
All right.
Honor.
All right, Laura Sterry.
Medical research, Your Honor.
Ms. Sterry is a medical reset. Juanita Hicks.
No problem.
All right, Ms. Hicks, you're before the court because you have two charges of violation of felony probation for which your judge issued a no bond holds. So I find probable cause, and you will see your division judge on February 4th at 8:30 a.m.
All right, thank you, Judge.
All right, Maria Trave,
Medical reset.
medical reset.
Yes.
Billy Santis Tebin.
No problem.
Hi.
Hi, how are you?
Not so good.
Yes, I see that. You're before the court again on one charge of possession of heroin, and number 2 is resisting officer without violence. I find probable cause. You have $1,000 bond on charge 1, and that bond will remain. Marcus Beckford.
What about the resisting arrest?
No bond is required, I'm not imposing one, so you have a total of $1,000 in bond.
Your Honor, I'm being told that Beckford is a reset.
Beckford is a reset? All right. All right, and Norris Palmer. Mr. Palmer is before the court on an out-of-state felony hold. It is a no bond hold for the state of Georgia. I find probable cause, sir, you will have to go before the extradition court, I think, on Tuesday. They have extradition court on Tuesday and Thursday, so more than likely you'll get on the Tuesday's docket. All right, Jose Rodriguez.
Mr. Rodriguez is approaching, Your Honor.
Okay. Mr. Rodriguez is before the court on a touch or strike battery. It's domestic. I find probable cause.
In regards to his bond, Your Honor, he has been a South Florida resident. He does live with his girlfriend, who's, I'm told, not the alleged victim. The alleged victim and Mr. Rodriguez do not live together. He can afford up to a $500 bond.
All right, state.
Your Honor, I do have conflicting statements here from the victim, Maria Gonzalez, as to whether or not she lives at 270 Plumtree, which is where the incident took place. Originally, she stated to the officers that she did, and then in her victim notification, she stated a different address. The state doesn't have an objection, though, to the ROR, just no victim contact and a no return if, in fact, they are living together.
All right, so Mr. Rodriguez, I'm gonna ROR you to pretrial supervision, and no victim contact, sir. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Also, you need to report to the pretrial office no later than Monday morning. They're not open on the weekend, so obviously Monday morning. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes.
Okay. Is this the case that you're calling? All right.
I never received a court notice, and my client, who's an electrician working this weekend, has a current bond KPS for a simple disorderly intox. It states an agreement that if he's going to appear on the 3rd, which was our original calendar date, in front of Judge Diaz, they would agree to quash the warrant until Monday.
State?
Your Honor, no objection. He's represented that he's received a notice for another date, so.
All right.
Thank you, Judge.
You're welcome.
And I do like how the court indicated that it is the 1st of February, and also the first Black History Month, a very important month. I wonder when the notice is.
Keith Youngswick.
No objection.
Keith Youngswick. All right, Mr. Youngswick is before the court on one charge of touch or strike battery. It's domestic. I find probable cause.
Your Honor, he does not live with the alleged victim. He is a South Florida resident. He does have a job. We asked for ROR, pre-trial, or he could afford up to a $500 bond.
Judge, the state would agree with the $500 bond, just no victim contacted or no return to the address.
All right, $500 bond, no victim contact. And no return. All right, Jonathan Bonilla.
No problem, Jonathan. Judge Powell, can you put him on a brief recall? I've got to get some of the ladies out.
Certainly, that's fine.
Thank you.
All right,
Thank you.
Howard Watson. You tell me when you're ready for Mr. Bonilla, Deputy.
Okay.
Okay.
Thank you.
Howard Watson.
Mr. Watson is approaching, Your Honor.
All right. All right, Mr. Watson, charges 1 and 2 are misdemeanor capuses. Your judge issued a $1,000 bond on those. And then on charge number 3 is a felony capias, where the judge issued a no bond hold. I find probable cause. It looks like you have, court on February 5th at 8:30 and also on February 4th to deal with these matters. Good luck, sir. James Wilson. Are you ready, Ms. Carr? You want me to, this is a MO case that but I have 2 others that we've put aside. We were waiting for you. So do you want me to just put this aside or? All right. Michael Fields, Mr. Wilson will recall. His attorney's getting ready. And so, Michael Fields is also a MO? Yes. So we'll recall Michael Fields as well. Thomas Wright. All right, Mr. Wright, you're before the court. You have 2 misdemeanor capiases. The charges are trespassing on both charges of trespassing. And you have a $25 bond on each of those. Or you have court on February 4th before your division judge.
Your Honor, he wants to know if he can resolve his case today.
Is there an offer?
Adjudication 5 days, Broward County Jail.
Okay. All right.
We didn't hear the offer.
5 days in Broward County Jail.
He's willing to resolve, Your Honor.
All right, Mr. Wright, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. And Mr. Wright, do you understand the offer that has been extended to you?
Do you understand the offer?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, Your Honor.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, Mr. Wright?
No contest.
No contest.
All right, I accept your no contest plea. I find that is freely and voluntarily given. Your sentence, sir, adjudication 5 days in the Broward County Jail. Keon Thompson.
No problem.
All right,
And also, I have Mr. Dania now.
okay. All right, so Mr. Thompson,
Yes, good morning, Your Honor.
good morning, Mr. Thompson. You're before the court this morning for a trespassing charge. I find
Yes,
probable
ma'am.
cause. Mr. Thompson has a $25 bond.
Judge, I spoke to Mr. Thompson this morning. He's unable to afford the $25 bond. He is interested in resolving the case today to time-served adjudication.
All right, Mr. Thompson?
Yes, ma'am.
All right, I will sentence you to time served, but, I'm also going to order that you don't go back to this location. Do you understand that, sir?
Yes, ma'am. Yes, ma'am.
All right, sir.
Absolutely.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Thompson, do you understand everything we've discussed here today?
Yes, you said that I will begin time served, and you told me not to go back to the location where I got the trespassing from.
All right, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
I have a depression, mental illness. That's it, but I never have been treated for it like that.
Is there anything about that illness today that would prevent you from making a decision about your case?
No, ma'am. No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served, and I'll give you 6 months to pay your court costs. All right, Jordan Boggs.
So, Your Honor.
Yes, sir.
Your Honor.
Yes.
Do I get released today?
That's what I said.
All right, I was just making sure, Your Honor. Thank you.
Okay. Jordan Boggs.
He's at Maine, Your Honor. Davika Carr on his behalf.
All right. Mr. Boggs has 4 municipal ordinance violations, and I find probable cause.
Yes, Your Honor. Mr. Boggs would like to resolve today if you are inclined to giving him time served.
All right. Mr. Boggs, you wish to resolve your case today, is that correct?
Yes, ma'am.
All right. So, all right. So I'll sentence you to adjudication and time served. Do you wish to accept that?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Mr. Boggs, do you understand the offer that has been extended to you today to resolve your case?
Yes, I do.
Is anyone forcing you to resolve your case?
No, they are not.
Are you under the influence of drugs or alcohol?
Not at the moment.
Do you need any more time to speak with your attorney?
No, I do not.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
And you understand that if you're not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes.
Yes.
All right. Have you ever been treated for mental or emotional illness?
No, I have not.
All right. So what plea do you wish to enter at this time?
No contest.
No contest?
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you, Your Honor. Have a good day, Jordan.
Hey, man. Appreciate it.
All right. Edward Christie.
She's done the other ones.
You have a-
It's actually a VOP,
Oh.
misdemeanor, not a KPS.
Okay, so on Mr. Christie, thank you. So on Mr. Christie is actually a violation of misdemeanor probation, and that judge did issue a $500 bond. And he is scheduled to see Judge Carpenter Toy on February 4th at 9:30 a.m. Okay?
Thank you, Your Honor. Coleman.
Vernon Dale Coleman.
He's approaching, Your Honor. Morning, Vernon.
All right, Mr. Coleman, you're before the court for a municipal ordinance violation, and I find probable cause.
Yes, Your Honor. It's a trespass, and he'd like to resolve to time served today.
All right, Mr. Coleman, you wish to resolve your case today?
Yes, ma'am.
All right, sir. Your sentence will be time served. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest, ma'am.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served. Good luck, sir.
Thank you, ma'am.
Have a good day, Vernon.
Eddie Wright.
Also at Maine, Your Honor, and approaching.
All right, Mr. Wright is before the court also on a municipal ordinance violation.
Yes, Your Honor, I spoke to Mr. Wright. We have no objection to probable cause. He believed that he had resolved this already, but Mr. Wright, this is a new violation. So if you'd like to resolve today, I'd be asking for time served.
Yes.
Okay, so, Mr. Wright, you'll be sentenced to time served. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. Good luck, sir.
Have a good day, Eddie.
Bill Polashek.
He's coming up, Your Honor.
All right,
Your Honor, did you want to wait till the end to recall the other ones? No?
after this, I'll,
Okay.
get to that. All right, Mr. Polashek is before the court on a misdemeanor capias. And that capias was issued August 28th of 2019. He did not show up for arraignment on a petty theft charge. So, what does Mr. Polashek want to do today?
He's interested in resolving his case, Your Honor. Can we do withholding court costs on his case?
Does he have any priors?
Judge, I'm showing no priors at all, and if he'd like, he can resolve to withhold court costs. There are also, pretrial intervention options that he may want to consider.
All right, so
Is he able to do the misdemeanor diversion program entering it in today, or does he have to come back, he has to go back to division court?
That's correct. We could not enter him into the pretrial intervention
Okay,
program today.
so that's the option he wants to take. In regards to his bond, Your Honor, he cannot afford a $500 bond. He is willing to do pretrial release.
The state has no objection to that, Your Honor.
all right, so I'll release Mr. Polachek to pretrial supervision. And sir, once you get out, I know you if you want to pursue that pretrial intervention program, you're gonna have to work towards doing that. You can't just not show up. So I'll release you to pretrial supervision by Monday morning. You need to report to the pretrial office. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
And also, if you have an attorney, you need to stay in touch with them so that you know what needs to be done for you to get into the program.
Okay.
All right. All right, Deontay Reddick, I'm sorry, hold on just a moment. Let me go back to those MO cases.
Thank you, Your Honor.
But just before your MO case, let me go back to Jonathan Bonilla at the North Broward.
Morning, Your Honor.
Good morning, Mr. Bonilla. Mr. Bonilla, you have a touch or strike battery charge. It's dating violence.
Yes, ma'am.
And I find probable cause.
Judge, I spoke to Mr. Bonilla this morning. From what I'm able to see, he has no Florida priors, and as far as I'm aware, he has no priors whatsoever. He resides in South Florida. His mother lives down here with him as well. He can live apart from the alleged victim. I'm asking for standard pretrial.
Stated the objection that the state's asking for a little bit of elevated bond in this due to the method. Trying to use the top of his head to hit her, which is kind of scary considering that.
I'm sorry, he tried to do what with the,
I'm sorry, what was that, ma'am?
repeat what you said. I
Last
heard
one.
something about top of head. I
Yeah,
don't.
the PC alleges that he tried to use the top of his head to strike her,
which could have caused great bodily injury had he done so. Also, he puts as there 9167 Ramblewood Drive as his residence. However, that is the address of the victim as well. There's no evidence that he has another address to reside at, and he has no residency anywhere in Broward County. So we'd be asking for a $1,500 bond on this misdemeanor. Along with, of course, no victim contact and no return to 9167.
Judge, we have no objection to that. He can't return to that address. Like I said, from my understanding, his mother lives down here. He could live with mom.
If Your Honor was looking for the exact language that the state cited to earlier, it's on page 2, about 10 lines down. The Bridge of Reimer's nose, who's the alleged victim, did have an injury which was documented using body-worn camera. Reimer stated that she began kicking in an attempt to get Bonilla off of her, and he head-butted her in the nose, causing her to bleed.
All right, I am going to impose a $2,000 bond, no victim contact. And no victim contact means no phone calls, no text messages, no social media, no third-party contact, okay? What are these
This
two?
is domestic violence. It was left out.
It was
And
left
this is
out of the docket?
Yes. I mean, it's on the docket, but it was just left out of your paperwork.
Oh.
Domestic violence.
And what is the other one?
That's the very last case on the docket.
Okay. All right, let's address these MO cases. Michael Fields.
Is that mean, Your Honor?
All right, Mr. Fields is before the court on a KPS on a municipal ordinance violation matter.
Yes, Your Honor. No objection to probable cause. Mr. Fields, would you like to resolve your case today?
Yes.
Okay,
All right, Mr. Fields, I'll sentence you to time served. Do you wish to accept that?
thank you, Judge.
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, 6 months to pay your court costs.
Thank you, Your Honor. Have a
James
good day, Michael.
Wilson.
He's also at Maine, Your Honor.
All right, Mr. Wilson, good morning. You're before the court on a misdemeanor KPS on a municipal ordinance violation. The charge is petty theft. What does Mr. Wilson wish to do today?
Your Honor, I'm asking for time served, and because it's a petty theft, I did review the NTA. There was no restitution. The items were abandoned and recovered.
All right. So, Mr. Wilson, you wish to resolve your case today, sir?
Yes, ma'am.
All right. You'll be sentenced to time served. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, sir. Yes, ma'am.
Okay, you can put your hand down. And Mr. Wilson, do you understand the offer that has been extended to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, sir.
Have you ever been treated for mental or emotional illness?
No, ma'am, no.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, sir? Guilty or no contest?
No contest, ma'am.
I accept your no contest plea. I find that is freely and voluntarily given. Your sentence, sir, is adjudication and time served. Bree
Have a good day,
England.
James.
All right. So Miss England is before the court because there is a misdemeanor KPS on a prostitution charge. It says she did not show up for a hearing
That's correct, Judge.
from 2018.
Miss England, did you want to resolve your case today?
Yes.
Your Honor, would you be willing to give her a withhold?
Well,
Although I don't know her priors.
do we know what her prior, if the state would be able to?
Thank you, State.
It looks as though she has open warrants out in Miami-Dade for her arrest as to a DUI.
All right. Well, all right. So I'll grant the withhold adjudication and court costs on this case. Miss England, do you wish to accept that?
Yes.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right. You can put your hand down. And do you understand the offer that has been extended to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
Yes.
You need more time to speak with your attorney?
Yes.
Okay,
Okay, I'll call her.
all right. Paula Rakel? Is she at North Pratt? Okay.
She said, yeah.
All right, Ms. Rakel, you're before the court because you have two misdemeanor cases. And, one is a state charge, one is a municipal ordinance matter. And not show up for arraignment.
Is there any way I could get out today, Your Honor?
No, and Ms. Rakel's been before this court, before me when I was, in first appearance many times.
Someone intentionally broke my hands.
And,
And it
so,
doesn't feel good.
based on the allegations, I am going to leave the bonds in place at
Okay,
this
Your Honor.
time, okay?
Your Honor, I'm not sure which division she's assigned to for the municipal ordinance, but would you be inclined to transfer her to mental health court, perhaps?
I can do that. I'll sign an order to transfer to Judge Lerner.
Thank you. Madam Clerk, do you need me to prepare that?
Intentionally attacked me on the very Holly with a stick. And some man has my
Well, let's
Jake,
do
my
both
baby
of them,
card,
if Judge Lerner will.
and spending my money. I'm gonna have to, I'm afraid, plead not guilty.
All right, Ms. Rakel.
Certain charges against everybody.
All right, Ms.
The
Rakel.
State and cities of New Mexico.
All right, we're done
Sheriff.
with Ms. Rakel, deputy.
Yeah, I bet you are, but you got your use sovereign, didn't you?
And Judge, based on her complaints, I'm just gonna ask for a medical evaluation.
Okay. All right, Deontay Reddick. All right, Mr. Reddick is before the court. Charge one is a traffic KPS. Number two is a civil writ, that has a purge amount of $1,528. That's not from magistrate, I'm just letting you know. I find probable cause. Driving while license suspended is a charge. I'll leave the bond at $500, okay?
Thank you, Your Honor.
All right. Herbie Luima. Mr. Luima is before the court on a touch or strike battery. I find probable cause for this charge.
Your Honor, he's been a Broward resident for 19 years. He does have a job. We're asking that bond to be reduced to $500.
Any prayers on Mr. Luima? All right, I'll leave the $1,000 bond in place. All right, and no victim contact. Carl Davis.
He bonded, Your Honor.
All right, Mr. Davis bonded. I find probable cause. Emmanuel Okwor. Thank you. Emmanuel Okwor. All right, good morning, sir. You are before the court for some additional charges. 5, 6, 7, and 8. They're all felony capuses with no bond holds. And my notes tell me that you have an arraignment before your division judge on February 10th. So
And Judge, he's for no bond for magistrate. He needs to be magistrate. He's being held no bond on counts 3 and 4 already anyway, regardless of what happens this morning. I'm asking for $1,000 a count.
Your Honor, I had Mr. Okwar in division. These are very serious charges. The state would be asking for a $10,000 bond amount on each count.
how much bond does he have on the other charges?
Give me one moment, Judge. But I know on counts 3 and 4, those are no bond. I'll see about.
Okay, I see. All right. I'm sorry, what was that? All right. All right, so I'll grant the $10,000 bond on these 4 charges. Okay?
Thank you, Your Honor.
All right. 10,000 each. Oswaldo Balzan. Where, Conti? All right, Mr. Balzan is before the court on, this is an ad charge for a felony capias for driving under the influence.
Your Honor, I had already bonded out on that, and they gave me pretrial. The morning that the judge revoked my bond on another charge, I was supposed to attend pretrial, and I believe that's what this is about.
Hey, Judge, I'll give Your Honor the dates. That he's been in custody since January 16th. And then this was issued January 30th. I don't know why the capias was issued, but it shows that he's been in custody since January 16th. And so I'm just asking for Your Honor to vacate it. He's still being held no bond on count 1.
Verify this information. Okay, so you're asking me to ROR him on this?
I don't know what the original.
I've already bonded out on this charge.
Yeah, so then if I can't see if he's bonded out on it. I'll ask for an RR or whatever was in place.
Well, if he's already bonded out, then.
Because of this charge, the other judge revoked my bond.
Hold on, Mr. Balzan, all right?
Sorry.
Yes?
It was 2 counts. It was DUI, alcohol, or drugs for the subsequent offense. And count 2 refused to submit to DUI test. He placed me
Did he have bond and pretrial on that case? Okay,
And he ended up getting picked up for another case that predated the DUI.
that predated.
Yes.
Okay,
That's why he did, that was the original reason why he's back in custody. And now the case is now been added.
so the KPA shouldn't be there, because it was,
So,
right?
Right.
Because it predated the,
right, I have no objection to the no bond hold, that's her holding him no bond. For this, what's before us today,
all right, I'll RO arm on this,
Right.
okay? All right, Carl Monaco.
He's approaching, Your Honor.
And you're ready on Miss England, Ms. Carr? All right, so we'll call that next. Mr. Monaco is before the court. Charge one is driving while license suspended, third or subsequent offense. Number two, failure to register motor vehicle. Number three, attaching registration license plate not assigned. I find probable cause.
Your Honor, can we reduce the bond to 500?
Does Mr. Monaco, does he have any priors?
Yes, he does, Your Honor. He has, felony petty theft, credit card theft, stolen credit cards.
The mic's not on, we can't hear the state.
I apologize. So two 2018 felonies for theft-related charges, a 2017 Burke conveyance.
It looks like he may also be on probation.
Let me
All right, I'll leave the bond in place at $750. Bree England, if we'll go back to Miss England.
Yes, Your Honor, and for the record, Ms. England had questions regarding the outstanding warrant that's in Miami-Dade. I advised her that it's active for failing to appear. She said that if she can continue resolving this case today, then she'll go turn herself in for that.
All right, so Miss England, I believe we were at the place where I asked you, did you have any other questions for your attorney?
Yes, ma'am.
So what is the answer now?
If you can release me today, I will go turn myself into Miami-Dade.
All right, well, I'm not, are you resolving the case? Do you want to resolve the case?
Yes, I do resolve.
All right, so if you're resolving the case today, then you will be sentenced to withhold and court costs. When you get released, or at the time that you get released, is going to be up to the jail. So do you understand that?
Yes.
All right, so, you understand that by resolving this case today, you're giving up your right, to trial?
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is withhold adjudication and court costs.
Thank you, Your Honor. Have a good day, Bree.
All right.
Your Honor,
You're welcome.
can we go back on Mr. Carl Monaco? He's willing to do pre-trial release instead of having the $750 bond.
No, I'm denying that. $750 bond. Todd Olson. All right, Mr. Olson is before the court. Charge one is threat to throw, place, or discharge destructive device. Number two, disorderly conduct. Number three, resisting officer without violence. And I find probable cause.
Your Honor, Mr. Olson is a resident of Broward County. He's currently not working and can afford a bond of up to $500.
Does Mr. Olson have any priors?
Yes, give me 1 second, Judge. Judge, I'm sorry, but I am showing a Lake Worth address, and I don't, if he is a resident of Broward County, that would be within the last few weeks, I believe. His most updated address would be at a Lake Worth. He does have traffic infractions in the last 6 months from Palm Beach, Volusia, Seminole. As far as priors, there is a domestic violence, and I don't know what the disposition was out of Polk County, and another domestic violence out of Citrus County, and that's all I'm showing, Your Honor.
All right, he'll have a $1,500 bond and no return. All right, Shaim White, 1,500.
Olson goes that way.
All right, Mr. White is before the court on charge 1, criminal mischief.
One step that way.
And number 2 is a violation of felony probation. You have a no bond hold for that matter, and $25 bond on number 1. I find probable cause, the bonds will remain in place. David Taylor.
I'm requesting for him to be reset for tomorrow. He was booked incorrectly. Count 1, take his felony, it was a not in custody, and they didn't book him for magistrate, so I'm asking him to send him for tomorrow. So it's looking incorrectly.
Judge, my only concern, I don't know why we need to reset it. I just don't understand the machinations because it is a bondable offense. On that capias itself, it actually says that he's being held no bond for magistrate. It says that on the capias, and so I just don't get the machinations why we need to reset it, hold him no bond for an extra day when it's not in custody.
Well, they do have the felony case number on my paperwork, so that's not a difficult thing to fix. All right, the charge, what is the actual charge is felony litter law violation.
And Your Honor, Mr. Taylor is informing me that he never received notice
It's
of.
a not in custody. It's not that he missed court. It's a not in custody capias.
All right, I am going to set a $2,500 bond on that.
He won't be able to afford that, Your Honor. He is retired. Would you be willing to put $500 and release him to pretrial?
No, he has a $2,500 bond. I am going to leave it at that, and the other standard bonds. Plus, he has an out-of-county misdemeanor hold, and that for Sarasota, where he also has another $2,000 bond. Okay? Laponso Lucas. All right, Mr. Lucas is before the court. Charge 1, burglary, occupied dwelling unarmed. Number 2, resisting officer without violence. Number 3, burglary, occupied dwelling unarmed. Numbers 4 and 5, burglary on occupied conveyance unarmed. Number 6, resisting officer without violence. 7, 8, grand theft, $1,000 or more, but less than 20,000. Number 9, burglary on occupied conveyance unarmed. And number 10, resisting officer without violence. And I find probable cause for these charges.
In regards to his bond, Your Honor, he is 18 years old. He's currently enrolled in a GED program at AMI. He lives with his dad and stepmom. I spoke to him about having a monetary bond. Right now, I see he's at $2,300. He said he should be able to afford that and probably nothing more if we can bond plus pre-trial.
All right, State?
Your Honor, I'd like to, if Your Honor would like, I can approach, but he does have juvenile priors.
All right, you just need to tell me that. That's
Okay. There are 8 prior juvenile arrests out of Miami-Dade. 1 is currently open and pending.
okay. All right, these are serious allegations and does have cause for concern for the community. These are charges of going into persons' garage while they slept, entering into an unlocked Ferrari, entering into an unlocked Mercedes. That's at one home. This is like throughout a neighborhood. Then to another home, another car was burglarized in the person's driveway. Then at another address, there was an attempted entry into another vehicle. At the first location in the garage, the persons were at home, so this court does have cause for concern for the community. So as to charges 1, 3, 4, 5, and 9, the bonds will be $2,000, and then the other standard bonds will remain in place.
Your Honor, may we have a order to take photos of of Mr. Lucas, please?
Certainly. Frankie Joseph.
Medical research, Your Honor.
Mr. Joseph is a medical reset. Clifton Dyer. Mr. Dyer is before the court on a violation of felony probation before Judge Colra. He does have a no bond hold, and he is scheduled to appear before Judge Colra on February 4th at 8:30 a.m. I find probable cause. Jason Elk. Mr. Elk is before the court. Charge 1 is not for magistrate. Failure to use sidewalk. Numbers 2 and 3 are violation of felony pretrial on a warrant. One has a no bond hold and the other one has a $100 bond. All right, I find probable cause. Darrell Bell.
I'm being told he bonded.
Mr. Bell bonded. I find probable cause. O'Brien Fields. All right, Mr. Fields, you're before the court for 2 charges of violation of felony probation, both of which have been issued with no bond holds for your division judge. You will appear before your division judge February 4th at 8:30 a.m. I find probable cause. Randy.
Okay, thank you.
You're welcome, sir. Randy Coach. Mr. Coach is before the court. Charge 1 is driving while license suspended. 3rd or subsequent offense. And number 2 is a traffic infraction not for magistrate. I find probable cause.
We're gonna leave the bond as is, thank you, Your
All
Honor.
right. And Bradley Leonard.
He's approaching, Your Honor.
All right. Mr. Leonard is before the court on one charge of possession of cocaine. Number 2 is traffic infraction not for magistrate. I find probable cause.
Your Honor?
Yes.
He's currently on pretrial in case number 1901.
Speak into the mic, please, we can't hear.
He's currently on pretrial in case number 19013631 CF10A for felony petty theft. Pretrial is asking that you revoke his pretrial. He was placed on in magistrate November 15th. You did it.
Okay. And what other priors does he have, other than what's pending in the felony?
Well, Your Honor, as far as the PC, the officer does say that he recognizes him from a previous arrest just a week or two prior for possession of crack for a crack pipe. We'd be asking that the $1,000 bond stay in place.
All right, Mr. Bradley, on case number 19-013631 CF10A, I will grant pretrial's request to revoke your pretrial. I'll set a bond at $1,000, and I will leave the bond in place on the new arrest also at $1,000. All right, Ricardo Nuno.
He's at Conti, I'm told.
Thank you. We're waiting for Ricardo Nuno. All right, Sean Shalev. Mr. Shalev is a medical loan, thank you. Ryan Woods Malley.
That's also a medical loan, Judge.
Medical loan.
Medical loan.
Ronald Robillard.
Medical reset, Your Honor.
Medical reset. Walter Simmons.
He's at Conti.
All right, I'll recall it. Elmine Shabazz.
Medical reset, Your Honor.
Medical reset. And Enrique Vargas Torres. Medical loan. The clerk has given me a mark for Cond. Is he there? They don't have Cond. And what's this other one that you said? Medical reset on Cond? And what is this one for?
That's the very last case.
All right, Antonio Jones.
He's approaching, Your Honor.
So Mr. Jones is before the court on one charge of possession of cannabis 20 grams or less. And number 2 is a violation of felony probation with a no bond hold.
Yes, ma'am.
That one is okay. So I find probable cause. I'll leave the bond in place on charge 1, okay?
Thank you, Your Honor.
All right, so we just need to figure out where Mr. Simmons and Mr. Nuno are.
He said 5 minutes.
5 minutes?
They're bringing him up.
Your Honor, we're all done at the main jail. May I be excused?
Yes, ma'am, thank you very much.
Thank you very much, Your Honor. Have a good day.
You too. We didn't need your services today. Everyone spoke English, no? Maybe you, huh? Maybe. I have 2 more. I'm waiting.
We had a, corrected error. They're asking, we evidently had bonds that the judge said for him to,
Oh.
Stay. Now I just hang out and eat. Now I just hang out in ECU all day.
Your Honor, I have Nuno right here. Mr. Simmons is on his way.
All right, thank you. Ricardo Nuno, Mr. Nuno, you're before the court this morning. Charge 1, distribute or deliver cocaine. Number 2, using two-way communication device to facilitate a felony. 3.
Spanish? Excuse me?
Oh, there you go.
Buenos días.
All right, so Mr. Nuno is before the court for 1 charge of distribute, deliver cocaine.
Okay, señor Nuno está delante del tribunal por un cargo de distribuir o entregar cocaína.
Number 2 is using a two-way communication device to facilitate a felony.
Número 2 es el uso de un dispositivo con 2 vías de comunicación para facilitar un delito grave.
Numbers 3 and 4 are felony violation of probation.
3 y 4 son violaciones de probatorias de delitos graves.
And those have no bond holes.
Los cuales tienen una detención sin fianza.
Number 5 is distribute or deliver cocaine.
Número 5 es distribución o entrega de cocaína.
Number 6 is using a two-way communication device to facilitate a felony.
El número 6, uso de un dispositivo con 2 vías de comunicación para facilitar un delito grave.
Number 7, possess with intent to sell, manufacture, or deliver cocaine.
7 es posesión con la intención de vender o fabricar o entregar cocaína.
Number 8, possession of heroin.
8 es posesión de heroína.
Number 9, possession of oxycodone.
9, posesión de oxicodona.
Number 10, attaching a registration license plate not assigned.
10 es pegar una matrícula a las tablillas que no son asignadas.
Number 12, possession of bulletproof vests.
12 es posesión de un chaleco a prueba de balas.
And number 13, possession of drug paraphernalia.
Y 13, posesión de parafernalia de drogas.
All right.
Judge, just given the no bond hold, I would just ask for the convenience bonds to be left in place.
All right, so.
Dado la detención sin fianza, I would give the what, the last part?
Judge, no objections to the convenience
Sorry.
bonds being left in place, but if in fact he does bond out, we'd be asking.
No me opongo a la detención que está en lugar, pero pedimos que
For a level 1 GPS.
un monitor electrónico nivel 1.
All right, so I will leave all the bonds in place.
Dejaré las fianzas en pie.
I will add the level 1 pretrial.
Y añado nivel 1 previo a juicio.
And it appears that he has court on February 3rd before his division judge.
Aparentemente tiene cita en el tribunal el día 3 de febrero ante el juez de su división.
All right. Good luck, sir.
Buena suerte, señor.
All right. And then the one left is Walter Simmons.
He's en route.
They didn't come on the same.
Yeah. Simmons, Your Honor.
All right, so Mr. Simmons, sir, you're before the court. Charges 1 and 2 are violation of felony probation, and those have no bond holds. And number 3 is a felony, 3, 4, and 5 are felony capuses, also no bond holds and not for magistrate. So I find probable cause, and you have court with your division judge on February 4th at 8:30 a.m. Okay? All right,
Thank you,
sir.
Your Honor.
All right, you're welcome. All right, everyone, I think that's the end of our docket. Thank you very much, and enjoy the rest of your day.